I have to tell you, Mr. Welby, that I take it as kind of a fact-specific case, touching almost onto some kind of almost a judicial estoppel type of thing, where the court made a great deal of described in some detail the efforts by the prosecution to depict Dr. Roberts as it says, they use the term pillar of the community. It says the prosecutor elicited background information that would have led a reasonable jury to infer that Roberts was a pillar of the medical community. And they talked about how he was established as not only a person with very commendable medical credentials, but also a person of the most upstanding type of character, including being a faculty member at the State University and at the San Francisco Theological Seminary, had been chairman of conferences about religion and mental health, honored as essentially the Midwest Psychiatrist of the Year, a devoted family man with grandchildren. I mean, this is almost like a canonization process that the prosecutor apparently did in front of the jury, while the prosecutor knew full well that Doctor was, would have supported a conclusion that Roberts sexually abused some of his patients, was about to lose his medical license and his prestigious faculty positions, and stood a chance of going to prison. I think that's almost suggesting that the prosecution was willfully distorting the information to the jury. And also, I think it suggests the court felt that, and in fact, later events apparently justified that suspicion, that Dr. Roberts was so far along in the nosedive that it says it would have supported a conclusion. And rather, I suspect the court felt that the jury would likely have concluded that Dr. Roberts was not as was being portrayed by the district attorney. Now, that is different from this case in two respects. Number one, the derogatory information which you have about well, first of all, although Mr. Jimboys has in fact tried to establish that Dr. Long is a very experienced and knowledgeable expert in the field of toxicology, I don't think he's put him on quite the pedestal that the prosecutor in the Lynn case did. And additionally, it does not appear that you have such damning evidence about Dr. Long as did the defense in the Lynn case. And that is to say, and again, we get right back to what I think is the core reason for the ruling, is that yours would pretty much take a mini trial to err, whereas it looks to me like Dr. Roberts would have had no way out.
Well, Judge, I mean, frankly, I expected this portion of my cross-examination to take, my estimate was 10 minutes. I mean, it really was, to do the cross-examination on Stallings of Dr. Long. My estimation was probably 10 to 15 minutes. And I understand what the court's saying. I mean, this is damning about Dr. Roberts, yet at the same time, it doesn't necessarily go to the fitness of his opinions, which is really what's important. I mean, there's the bias of maybe he wants to curry some favor with the prosecutor, but I mean, his problem was his separate sexual abuse, but it didn't mean that he wasn't the smartest psychiatrist in the state or something like that. Whereas here, I'm going directly to qualifications, and it's not, I'm going to qualifications in a case that was an ethylene glycol homicide, which is a pretty rare bird to have these prosecutions, and in that very kind of case, there was an error, I believe an error of some substance. And you're right, Judge. I don't know the truth. I have to cross-examine on all sorts of things that I rarely would be in a position to know what the truth is of something I'm cross-examining, but I have a good faith basis for my cross-examination into his qualifications and what his conduct was in that case, and that's what I want to get at.
Yeah.
Not even close. Not even close.
Well, just a minute. Yeah, I might point out, because I'm glad you brought it up. The court made a point in Lind to point out, well, anyway, they took the trouble to point out that the prosecutor offered this evidence knowing that psychiatric testimony cannot be verified or refuted empirically, making the witness's personal and professional stature important to the jury. And that's not true here, because in this case there can be, and apparently you do have toxicologists to suggest other interpretations or even findings for the jury here?
I might prefer not to put them on, though. I mean, I don't have to.
But the point is that in the case where the prosecutor, I think that the real target here for the Court of Appeals was the prosecutor's conduct in deceiving the jury about what type of an individual Dr. Roberts was, and the court went to the extent of pointing out how dependent a jury is on credentials when you're dealing with psychiatrists, because it's all interpretation. So that, I think, is a significant difference from this case.
I just don't, I don't see what kind of mistake an expert could make in a prior case under this viewpoint that would ever be subject to cross-examination.
Actually, I think I agree with you, and that's what I said when I was posing the questions to Mr. Chambois. Do you mean to tell me if one of these so-called credentialed experts jazzed up 100 cases in a row that you couldn't get into that? And I don't care what the rule says. That's why I said the rules are made to be flexible. But I think that this case, what you're trying to do here, is right within the general,
It's scoring in the middle, what it can't do.
It's exactly what the rule was designed to prevent.
The court keeps saying a rule, and I don't know what rule.
The rule that says you may not, specific instances of the conduct of a witness for the purpose of attacking or supporting the witness's credibility may not be proved by extrinsic evidence. They may, however, subject to, if rape shield law, if probative of truthfulness or untruthfulness and not remote in time, be inquired into on cross-examination of the witness. And that's the rule we're talking about. You're going to have to take his answer, and you're not going to be allowed to ask him questions about things that, and Mr. Jambo's point is probably a very good one. If he predicts that correctly, that Dr. Long is just going to deny whatever suggestion you raise, what's the point? All you're then doing is creating suggestions for the jury without any evidence to back it up at all, and without the ability to present any evidence.
I've seen an awful lot of cross-examination. I prefer not to do those cross-examinations by and large, but I've especially seen prosecutors do that to defendants all the time. And
I hope not in my court.
Well, but if they ask the question and it's denied, then in cases say the jury can consider the demeanor of the witness in denying it even. I mean, that's what 90608 provides. Because I asked, for instance, with Thompson, I asked questions that he denied. I was stuck with the answer. I think some of them, the jury probably looked at him and said, I don't believe you whatsoever.
Maybe so. But I'm pretty comfortable with where I stand on this.
Well, are we going to put Dr. Long on?
And you can ask those questions that you want. Ask Dr. to come in, please. Could I have the stapler, please, for a second? Thanks.
Okay, Chris, you're up.
Well,
Here's another exhibit, Your Honor.
oh, thank you. All right, go ahead with your examination, Mr. Colby. I think it's on this.
Dr. Long, in 1989, you were asked to test the blood of Ryan Stallings, correct?
Yes, sir.
Ryan Stallings had died, right?
Actually, I think there were 2 times. One was this, and you have to remember, this is about 18 years ago for me.
Sure.
But I think the first time was the hospital admissions, and the second time was post-mortem.
Did you test the blood both instances?
I'm not positive. I know we did the post-mortem. We may have done the ante-mortem.
But you definitely did the postmortem.
Yes, sir.
That blood was taken at the time of the autopsy, I presume, of Ryan Stallings?
I would say so, yes.
And the prosecutor's theory was that his mother had given him antifreeze or ethylene glycol in a feeding a few days before his death, right?
Well, apparently there were, excuse me, 2 incidents. The first incident, he was hospitalized, and the second incident, he was with the mother, and she had a bottle, and he died as a result of the second incident.
And the second incident, he was in some sort of foster care or protective care at the time of the feeding, right?
Yes, by DFS.
And so there was a pretty precise window of time in which the mother had access to her child, correct?
I guess.
He died how long after that feeding?
I don't remember.
Do you recall that the blood, well, that the death was something like 96 or 108 hours after the feeding?
I don't recall. That was 18 years ago.
So you don't recall that being a significant issue as to whether ethylene glycol would still be in the blood over that length of time?
I don't recall how long it was as far as the hours.
Do you recall anything about the time?
No, sir.
Your test was positive for ethylene glycol?
Yes, sir.
That's what you reported?
Yes, sir, and we've changed our protocol since then.
And why did you change your protocol?
Because of the issues that were raised in the Stallings case that methylmalonic acid or one of the other acids from a biochemical disorder could interfere with ethylene glycol. So we changed our protocol and we include GC mass spec, which eliminates that.
Did you actually perform the GC mass spec in that case?
We didn't do GCMS in that case, no, sir. We changed it since then to include GCMS now.
Is it your testimony that you never performed a mass spec in that case?
There was something about that. I don't remember specifically, but there was something about mass spec.
Patricia Stallings was prosecuted for homicide,
Yes, sir.
and while she was in jail awaiting trial, she gave birth to a second son, correct?
Yes, sir.
Before her trial took place, correct?
I don't recall if it was before or after her trial, but she was in jail when she had the baby.
And do you recall that he developed symptoms similar to his brother Ryan while she was still in jail waiting for the trial?
That's what I recall, yes.
So that was known prior to the trial of Patricia Stallings, correct?
Yes, sir.
That he had developed symptoms that were attributed to antifreeze for Ryan Stallings, correct?
Yes, sir.
The second child developed these symptoms even though the mother had no access to them at all after birth.
That's correct.
At trial, you testified that, in your opinion, Ryan Stallings had been poisoned with antifreeze?
Yes, sir.
At that trial, you presented a mass spec graph, correct?
I don't recall. I vaguely remember something about it, but specifically, I don't recall.
Do you recall at that trial that you presented charts showing that your results in your testing for ethylene glycol matched the standard reference charts for ethylene glycol from a reference book?
I don't recall that, sir. I could have, I just don't recall.
Do you recall that you whited out a portion of the chart you used that reflected the GC mass spec for Ryan Stallings so that it would match the reference book?
Well, Mr. Jambo, I brought that up, and the question, it was either, if it wasn't done by the prosecutor or at the prosecutor's request, then I did it, and I wouldn't do it today.
You wouldn't do it today because why?
Well, for two reasons. First of all, it doesn't make any difference. It's easily explainable. And secondly, it gives a false impression that I'm altering the data.
Well, in fact, you are altering the data, correct?
No, I'm not altering the data. I'm altering the appearance, and that was for a presentation in the court, if that's what was done. It would have been, quote unquote, cleaning it up, and I wouldn't do that today. And I guess you're right, it is wrong.
Would it refresh your recollection to review your testimony from your deposition in the civil case?
I'm surprised you have that, because it was supposed to have been...
Can you answer the question?
Well, I guess if I sat and read through all of it, yes.
Well, if I gave you two pages regarding whiting out the chart, would that refresh your recollection as to what?
Sure, I'll take a look at it.
I'll show you from volume 2, December 21, 1991, pages 175 and 170. Actually, I'll show you 175 through 177 and anything additional if you'd like to do with it.
Yeah, I'd like to see it.
I'm going to give you 174 as well.
Okay.
Yes, sir.
Does that refresh your recollection about whether you whited out the chart for presentation to the jury in the criminal homicide case of Patricia Stallings?
Yes, as the request of the prosecuting attorney. For an exhibit, not for the hard copy data, but for the exhibit.
You didn't tell the prosecutor not to do that, right?
Objection, it's irrelevant what this witness would have told a prosecutor, what a prosecutor can or cannot do in preparing an exhibit for a criminal
Well, if
prosecution.
he prepared it, he could refuse to prepare it.
He didn't prepare the exhibit, Your Honor. He prepared a report. And then from that report, what the prosecutor did is ask this witness to white out certain numbers.
He did it, right?
And then that exhibit was taken and it was blown up into a larger
Point is
exhibit.
that he created the document. He could have
Yes.
said, I will not do that.
Yes.
Go ahead.
Did you protest to the prosecutor?
I didn't know any better, and no, I didn't.
And you whited out the numbers on the mass spec chart, right?
Yes, for the exhibit, not for the original data.
You presented a blown-up chart to the jury, right? Of the mass spec graph, right?
I don't know that it was ever used in the trial. I don't recall if it was or wasn't.
Well, you testified, did this refresh your recollection that you had testified in the criminal trial that Exhibit 15, which is the blow-up, was a fair and accurate representation of the actual graph in the run?
I testified to that in the deposition, yes, sir.
When things were fresh in your mind, right?
Yes, sir.
And you testified that you told the jury in the criminal case that the exhibit was a fair and accurate representation of the graph that had been produced by the mass spec, right?
Well, I don't know that I was asked that or that I said that, but
Well, the question is, did you make that statement in the deposition?
I believe that's in the deposition. No, in the deposition, he asked me if it was a fair and accurate representation, and I said, yes, I believe it is a fair and accurate representation.
Page 175, line 10. Question, doctor, do you remember testifying in the criminal trial? I'll show you the transcript. Page 440, when Mr. McElroy gave you State's Exhibit 15, that State's Exhibit 15 was a fair and accurate representation of the actual graphs of the run. Answer, yes, sir. Question, and what was your answer? Answer, yes, sir.
Then I did say it, sir.
And Exhibit 15 in the criminal trial was not a fair and accurate representation of the actual graphs of the run, right?
Well, it was not complete. It showed the ethylene glycol, but it wasn't complete. And if you want to argue fair and accurate, then no, it wasn't.
It was cleaned up to try to make a more persuasive case to the jury, right?
Objection, Your Honor. It was done at the request of the prosecutor. The prosecutor would be asked, which is the one that should ask that question.
Overruled.
It was cleaned up for presentation to the jury,
To make a more persuasive case, true?
to make it cleaner so they could understand it. I don't know if that's more persuasive.
So they wouldn't be distracted by the differences that existed between the reference material and your graph, which did not match the reference material, true?
Well, I guess so.
True?
I guess so.
In the Stallings case, you signed onto a report that erroneously stated 857 nanograms per mil rather than micrograms per mil. Is that right? Recall that?
God, it's been so long. It's probably micrograms and not nanograms. I don't recall signing off on that, but if you've got it sitting there, then I did it.
And you also signed on to a report that indicated that an ethylene glycol sample had been confirmed by GCMS when it actually had not been. Do you recall that?
No, I don't.
I'll show you pages 63 through 66. Volume 1, this is Volume 1, December 9th, 1991.
Yes, apparently that's what it was. It was the next sample was Ryan Stallings. And it said it was 3856 when actually it was 3863, which was the next sample for Ryan Stallings.
But you also misstated nanograms instead of micrograms, correct?
Yes, sir.
And then, in addition, you signed a report that said the sample's results had been confirmed by GC Mass Spec when it had not.
It was a different sample that had been confirmed. It wasn't 3856, it was 3863.
That is run number 3856 instead of run number 3863. Is that what you're saying?
This says that sample 3856 was confirmed by GCMS, and in point of fact, it wasn't. It was sample 3863, which was the next sample for Ryan Stallings. So I have to keep reading. Okay, yes, sir.
You signed a report indicating the sample had been confirmed when in fact it wasn't.
That is correct, sir.
You also ran tests on you did one set of tests on Ryan Stallings' blood and it came back negative, correct?
I don't recall that, sir.
Your Honor, I guess I'm going to request that this matter be continued, that I be provided a complete copy of this several hundred-page exhibit that instead of where there's little parts being taken out. I've never seen it before, never heard of it before. Wasn't made available to me before. And here I'm expected to sit here while this witness is spoon-fed small pages, small number of pages out of an exhibit. How many pages long is this deposition transcript, Counselor?
1,000.
Okay, 1,000 pages. And do you think that's fair? I had expected we were going to do an offer of proof where there's going to be a brief recitation, a brief examination of this witness concerning this prior case. But I guess we're now going to do it's not going to be a mini trial, Your Honor. It's going to be a macro trial. I've now got to familiarize myself with the enormously complex medical, legal issues and scientific issues that surrounded this bizarre, strange, unprecedented case from 20 years ago, where this infant died from a very unusual genetic disorder.
The problem is that the witness has already acknowledged that at the request of the district attorney, he prepared an exhibit which was manifested to the jury, which he now acknowledges was I want to be cautious.
It was different than the original exhibit.
Well, it more than that, and I don't want to use the wrong word here because we're talking about something very important, and I think precision is required. I will tell you that I've heard enough, unless there's some reason for me to hear something that would convince me otherwise, to permit the examination, especially since the doctor acknowledges some of this, and we're not into the business about having to have a mini trial, because if he takes his answer, it still damages credibility.
Well, Your Honor, except that I've not had an opportunity to review any of this, put any of it in context.
We're going to stop, because I already said we were going to stop at 4 o'clock. So that's question number one. Question number two, may Mr. Jambois have a copy of that at this point?
Problem is copying it. I only have one because it's so lengthy and I wasn't going to use very much of it, but I'm happy to give it to him for copies.
So that solves that problem.
And then, Your Honor, when were we going to revisit this issue, since I should be provided an opportunity? You know, the counsel has had years to examine this case that he was going to spring on this court in the middle of this trial, which he never notified me about.
You're suggesting he's done something wrong, and I'm not on that track. You haven't suggested that he's done something wrong, so I don't want to hear about it.
I'm not accusing him of
Well, he says as if he's been lying in wait. Look, he's not done anything wrong, and he's told you he will make it available for you to photocopy. So why don't you make a suggestion as to when you want to continue this?
I would say toward the end of next week.
That's fine.
Okay.
Thank you.
All right. Let's. You can deal scheduling between whatever scheduling you agree upon with Dr. Long. Please try to do so in conjunction with Mr. Albee, and we'll start at 9 tomorrow with Mrs. Voigt. Is that who's next?
Yes, Your Honor.
Okay, anything else?
No, Your Honor.
Thank you.